Hello, everyone. Thank you so much for joining us. We'll be beginning shortly. I just want to acknowledge our two ASL interpreters for today, Felice Shays and Michael Barrios. We will provide you in the chat with instructions on how to pin their video and a link to CART services. Thank you for joining us.
Well, good evening, everyone, and welcome to the Civilian Complaint Review Board's February board meeting. I'm Fred Davey, and I'm the chair of the board. And before we get started, I'm going to ask my colleagues on the board to introduce themselves. And I would like to start with Miss Irish, Corinne.
Hi, everyone. Corinne Irish. I am a mayoral appointee and from Harlem.
Miss Bond.
Good evening, all. I'm Erica Bond, mayoral appointee in Brooklyn.
Ms. Simmons.
Good afternoon, everyone. I'm the public advocate's appointee. I'm from Bed-Stuy, Brooklyn.
Michelle Obama.
Mr. Dwyer.
My name is Frank Dwyer, and I am a police commissioner designee.
I'm Mayor de Blasio to the board.
Mr. Puma.
Good afternoon, everyone. My name is Joseph Puma, the City Council's representative on the board from the Borough of Manhattan.
Mr. Rivenera.
Good afternoon, everyone. Michael Rivenera. I am the City Council designee to the board, hailing from the Bronx.
Mr. Freeman. I think you're on mute, Mr. Freeman.
How about now, everybody good?
Yes, we got you.
Okay, I'm Willie Freeman, Police Commissioner designee from Brooklyn.
Thank you. Thank you. And Dr. Tara.
Designate the board. I am Sal Carcaterra, and I am a police commissioner designate.
So thank you all. Before we go any further, I guess we should do a little bit of housekeeping. We need to approve the minutes from the last meeting. Is there a motion to approve those minutes? I saw a raised hand somewhere. Is there a second? All those in favor, are there any additions, revisions? Hearing none, seeing none. All those in favor of approving the minutes, please say aye or raise your hand. All those opposed, the ayes have it. 2 weeks ago, this board voted to adopt the guidelines within the NYPD's disciplinary matrix to our own recommendation. I signed a memorandum of understanding with Police Commissioner Shea to implement the disciplinary matrix. Members of the public and even from this board who are critical of the matrix and the NYPD's willingness to discipline officers who commit misconduct. However, absent legislative changes that address the police commissioner's broad discretion over discipline in CCRB cases, the disciplinary matrix is an important way to ensure the police commissioner and the department as a whole are more accountable to CCRB disciplinary oversight and to the people of New York City. Ultimately, the closer we get to CCRB having binding disciplinary authority in its cases, the better. And I believe the disciplinary matrix and MOU, the Memorandum of Understanding, bring us closer to it than we've ever been before. The disciplinary matrix is a living document, as we have said, and I look forward to strengthening it with all of you over the coming months and years. I also look forward to the CCRB playing a significant role in the conversation around other reforms the city and the state can take, including the transfer of final disciplinary authority to the CCRB in our cases. Tonight, we are brought together by a different reform, and that is our effort to restart investigations into sexual misconduct and clarify the CCRB's ability to investigate false official statements made against civilians by members of service. These two areas of misconduct represent some of the worst kinds of abuse of police authority, and I believe this agency is well equipped to investigate and prosecute this kind of misconduct. During our public board meeting on January 13 and the public comment period that preceded it, the CCRB received valuable insights from individuals, elected officials, and community organizations. The public comments were overwhelmingly supportive of the proposed rules and included a lot of thoughtful feedback about how to improve the proposed rules. The board carefully considered each of these comments, and in order to avoid any further delay in investigating sexual misconduct again, and untruthful testimony and untruthful written statements against civilians, we believe that the rules as drafted offer the agency a strong starting point and a strong starting position to begin these investigations. As our work on these cases proceeds, the board will continue to consider comments that we've received to further refine these rules. I want to thank the public for providing feedback on these rules and for being here today to observe our vote. I plan to vote in favor of adopting the rules, and it is my hope that my colleagues on the board will do the same. That said, the implementation of these rules, the matrix and the MOU, and any additional reforms made at the city and state level will only have a positive impact on our investigative work so long as transparency is at the center of the entire disciplinary process. In addition to providing the public with access to disciplinary information guaranteed by the repeal of 50A, it is critical that CCRB investigators have access to everything they need to investigate their cases. New rules and new authorities will only get us so far. Without evidence that is essential to our investigations, those very same investigations will suffer. Going forward, it is my hope that the city and the state examine ways to provide the CCRB with direct access to not just body-worn camera footage, but statutorily protected access to other documents and evidence that may be crucial to our cases. Like the disciplinary matrix, these rules changes are a first step, but they will only be as strong as the city and the state support for police accountability and for civilian oversight. I thank you, and I now turn the mic over to John Darsh, our Executive Director. John.
Thank you, Chair Davey. The agency is excited about the opportunity to better serve New Yorkers who experience sexual misconduct or who are hurt by a false official statement made by a member of service on police documents or an official testimony. 3 years ago, this board voted to begin investigating sexual misconduct. In the time since that board's initial vote, and despite delays brought about by lawsuits, our agency has built competency in this area, hired staff in investigations and APU to investigate what we term Phase 2 misconduct, and hired a director of what will be our new Civilian Assistance Unit. We've established a framework that we will use when we onboard caseworkers. This is an important night for civilian oversight of the NYPD, and we appreciate the members of the public being here with us. Some ground rules for this meeting. In the public session, please use the raise the hand feature to make a comment. Please restrict your comments to 2 minutes. If you would like to discuss a problematic encounter with an officer, please provide contact information so that our investigators can follow up with you. I would like to thank the staff for continuing operations during this difficult time during the pandemic, and thank again members of the public for participating in this meeting.
Thank you, Mr. Darsh. We're now going to have a presentation from our outreach department, and I think Jahai Rose is going to do that presentation. Jahai.
Okay, thank you very much, Chair Davey. Once granted, I'll be able to share my screen. Okay, thank you so much. Okay, can everyone see my screen?
Yes, thanks.
Okay, thank you all so much for attending today's board meeting. As the chair mentioned, I'll be providing a brief presentation regarding regarding outreach. As you may know, the CCRB, the Civilian Complaint Review Board, is the largest civilian oversight agency for the largest police force in the country. The CCRB investigates, mediates, and prosecutes complaints of misconduct against members of the New York City Police Department. As you've been introduced to, our agency is governed by a 15-member board. You've met many of them today, with 5 seats being appointed by the mayor, 5 being appointed by the New York City Council, 3 designated by the New York City Police Commissioner, 1 appointed by the public advocate, and the chair is jointly appointed by the mayor and the city council. While the Civilian Complaint Review Board has an ability to intake all types of complaints regarding misconduct from the New York City Police Department, we're only allowed to investigate 4 categories. We use an acronym called FATO in order to remember what those categories are. That may be a helpful acronym for you as well. The first acronym, the FATO acronym stands for force, which is looking for force that's excessive and unnecessary, abuse of authority, discourtesy, and offensive language. The agency also investigates the use of the Right to Know Act. So for those that may not know, there's a couple of things to know about the Right to Know Act. The Right to Know Act changes and may affect how New York City police officers interact with members of the public. The Right to Know Act was enacted in October 19th of 2018 and pertains to certain stops, searches, where it pertains to how a police officer should conduct themselves. So the 4 facts that you should know about the Right to Know Act include that an officer under certain circumstances should identify themselves by providing their name, their information such as their rank, command, and their shield number. With some exceptions, they should explain the purpose for the interaction. Officers should also inform you under certain circumstances of your right to say no when asking for your consent to search your person, property, vehicle, or home. And last but certainly not least, under certain circumstances, the officer should offer you a business card. The business card has the officer's information, explains how to comment and or complain about interactions with the New York City police officers. Civilians may request these business cards in all interactions, and this is an example of what that business card may look like. Now, there's a couple of ways to be able to report police misconduct. One way to file police misconduct is online at nyc.gov/CCRB complaint, or you can call the CCRB at 1-800-341-2272 or CCRB. So that's 1-800-341-CCRB. Now, reminder, if you see footage of misconduct on social media or in the news, you can file a complaint even if you are not in person. Even if you're not there in person. A couple of additional ways to file complaints about police misconduct include calling 311. You may also visit our office at 100 Church Street on the 10th floor in Manhattan, New York, zip code 10007. You can also visit any police precinct in the city of New York to file a complaint about police misconduct. You can also send a letter to our office at 100 Church Street. If you would like to request an outreach presentation for your community, for an organization, for a nonprofit, educational institution, or after-school program, feel free to reach out to us at outreach@ccrb.nyc.gov. You can also follow the CCRB on social media, on Instagram, Twitter, and Facebook. Thank you very much, Chair. Chair Davey.
Thank you, Jahai. Do any of the board members have any questions or comments for Jahai? Any aspect of his presentation? All right. Thank you, Jahai. We will now go to public comment. We'll hear first from our elected and public officials and then from the general public. And the public can comment on the rules changes or any other issue that they would like to comment on. So, Yahira, are you leading us through this portion of the agenda?
Yes, thank you. As a reminder, you can use the raise hand feature if you would like to make a comment. We kindly request that you keep your comments to 2 minutes. First, we'll be hearing from Chris Dunn.
Have to elevate.
Hey, Fred, can you hear me?
That's Chris. Go ahead. Welcome.
Okay. Good afternoon, Fred, and the rest of the board, and John. Fred, on the matrix, I'm not going to repeat the concerns that we have about that. They are extensive. What I do want to say is I think the CCRB has a really important role in terms of seeing how it actually works. And the CCRB has always been good about publicizing information and data. And I think it's really important that the agency do everything it can to make sure that the reporting about the operation of the matrix is complete and is timely, so the public and other people can have a very thorough sense of how it is working or how it is not working. And I think, I'm not quite sure when this is going to go into effect in terms of your reporting, but we are heading into an election cycle. There's going to be a lot of public discussion about the police department, about police discipline. And I would urge you to start reporting on this as quickly as possible. The month of March is a good place to start. With respect to the rule changes, we fully support those rule changes, as we've said before. I understand and appreciate the notion of finalizing these rules now and then proceeding to amendments. And we agree that it's very important for the agency to be able to start investigating sexual harassment complaints and to continue its work on false statements. So we thank you for that. If you need an 8th vote and Sal doesn't come through, and Sal, I'm counting on you to do the right thing. Fred, you can count me as number 8. Thank you very much.
Thank you, Chris. That would be quite the vote to take, I think. It would get a lot of attention. And just on the issue of reporting on the use of Matrix, our desire is to make sure that the public has confidence in this, in the use of this new approach to discipline. And so my commitment is to, as much as we can, until 58, the issues around 58 are resolved, as much information as we can make available, we will, and as soon as it's feasible to do so. And I think my fellow board members are committed to the same, as well as the staff of the CCRB. But let me see if any of my, if any of the other board members would like to comment before we move on to the next speaker.
Fred, it's always good to hear from Chris. That's all I'd like to say.
There you go, Sal. You sure you don't want to expound on that a little bit more?
No, I think that said it all.
Okay, thank you. Thank you, Chris. Next speaker, please.
Thanks, Chris.
Thank you, Chris. Before moving on to the next speaker, we just want to acknowledge a few folks from different offices. Eduardo Acevedo from the Public Advocate's Office, Latoya LeGrand from Senator Comrie's office, Carl Valerie from Assembly Member Anderson's office, Yen Cho from the Office of Assemblyman David Wempern, Erin Rose from Senator Robert Jackson's office, Marlon Rice of Assembly Member Zinnerman, Jack Connors from Senator Brand Hoylman's office, Monica Monson of the Office of Assembly Member Kenneth Burgos, and Wilbur Lamel of the Queens District Attorney's Office. Next will be here.
Thank you.
Thank you for joining us. Next, we'll be hearing from John Sonda. As a reminder, please keep your comments to 2 minutes.
At the November 9th, 2020 board meeting, Executive Director Darsh stated, "We are in the process of changing our disposition letters to inform complainants and victims of the reopening process in their disposition letter. That information should have been included in that, and we are rectifying the situation." Has that situation been rectified?
Mr. Darsh, you want to answer that? Mr. Darsh. John, are you on mute? Mr. Sun, it seems that Mr. Darsh may be having an issue with his mic. It looks like it's on mute.
Okay. My next question is, when was the 2019 annual report issued?
Is Haria on? Haria, are you on the conference in the room?
No, but we can have her upgraded in just a second.
Great. Okay. Mr. Sonda?
Yes. My question is, when was the 2019 annual report issued?
She's going to let us know in just a second. We'll have her put it in the chat. You have another question?
Mr. Chair, do you mind if I answer the first question? I'm sorry, I wasn't.
Go ahead, Mr. Doss.
So we are working with a group from California. I'm forgetting the name of the college right now. One of the state universities in California has a group that we're going to be working with that is going to examine all of our external communications with civilians, starting with disposition letters. So we have not yet changed our disposition letters. I changed some of the APU disposition letters that were giving incorrect information, but we still have a long way to go in fixing the disposition letters.
And that is it's the Goldman School, as I recall, at the University of California, Berkeley.
I think that's right.
Okay. Next speaker, please, Yahira.
Thank you, John. Let me just refresh my page. I believe that concludes our public comment portion.
Okay. Do we have any hands raised? No hands raised. Oh. So you to get someone to move work on so pursuant to City Administrative Procedure Act, CCRB published a draft copy of our rules on December 7, 2020. For more than 30 days, the CCRB accepted public comment. On January 13, 2021, the CCRB held a public hearing to discuss it. I'm going to ask our board members if they will mute their mics, please. Thank you. After careful consideration of the public comment, established the final version of the new rules on our website on Thursday, February 4th, 2021. At this time, I would like to take a final vote, and may I have a motion to approve the rules governing the board's investigation of sexual misconduct and untruthful testimony and written statements against civilians. Is there, would someone move that?
So moved.
Is there a second? Thank you, Ms. Bond. And so we'll open it up for comments from the board member. Mr. Dwyer had a comment. Mr. Dwyer.
Mr. Chair, I do not support the rule changes as proposed here, and I will express a few of my objections, certainly not all of them. And I will, consistent with parliamentary procedure, make a number of secondary motions, which I would encourage my members, my fellow board members, to seriously consider before we move forward. First, it concerns me that we have over 100 pages, well over 100 pages of public comment to study and determine which recommendations to incorporate. And I've read them all. It's not that I haven't. I've read them all, and they're complex and often rich. I know that when we have conducted public hearings regarding the police department's disciplinary matrix, we received many pages of public comments. And in that case, we studied them and we sent a letter to the police commissioner with recommendations concerning how to proceed. At our last meeting, our assistant legal counsel presented to us and to the public what those recommendations were, which ones the police department had adopted, and which ones they had not adopted. We did that in terms of another agency. I think if we are going to do that in terms of another agency, we should do that in terms of ourselves. I'm acutely appreciative of what you are saying, that we can move forward with these rules and then modify them later on. But my experience in government is even the best intent often does not get followed up on because new challenges, many, many new challenges get in the way. So my first subsidiary motion is that the staff prepares a matrix of the recommendations, that we review them publicly, as I understand that it's required by the open rules law, and that we decide what to include in here as we would, rather than just saying that we shall just move forward what we have. So, I mean, I can make that into a shortest motion. Or would you just like to throw it open onto the floor to get a discussion among all of us who are board members?
So if we get a second, we can discuss it as an amendment to the motion. Is there a second to what I will designate as an amendment to this motion? Is there a second?
I'll second that, Fred. Just I want to hear what I'd like to hear some opinions on that.
Okay. Well, this amendment has been made and seconded. Other comments?
John Siegel here. I appreciate the suggestion and the concern. I do see, though, a pretty key distinction between these rules and the matrix. Namely, these rules were drafted by CCRB at the end of a long deliberative process of fact-finding from people involved in relevant issues and discussed over a period of time by the board. And as compared to the matrix, which was drafted by the police department and therefore required us to go through the process of public comments on their draft because we didn't have any other input into it. So I see that as a pretty critical distinction in the process leading up to the adoption of this rule versus the matrix.
Other comments? Thank you, Ms. Siegel.
I certainly think that it makes sense to do that and to look at the recommendations that we've received and to look at them carefully in the matrix or however. I just think we can do that as well as vote for the rule as is, and then move forward with looking at ways to improve it.
Thank you, Ms. Irish. Others? Ms. Vaughn, go ahead.
No, I just add that I agree with Corinne on this. I think, as the board chair noted at the beginning of this conversation, it's been 3 years now. And during that time, I'm sure there are individuals who would have liked to avail themselves of the opportunity to report these kinds of issues. And so I just don't think we can afford to wait any longer if we're going to be responsive to the needs of civilians in the city. And it's for that reason that I think we should move forward with these rules. And as Corinne noted, I think take into consideration a lot of the comments that have been given to us, but incorporate them into the next round of revisions.
Thank you. Others? Ms. Simmons?
As everyone noted in the last meeting, I have several problems with the matrix. However, I believe our monitoring, self-monitoring, what happens going forward and problems that we think may have been predicted by the public, noting them as they go forward, is absolutely necessary. We already said we were going to do it. The mechanism for doing it, I think, needs to be as detailed as possible. And I think we do need to keep track of the issues raised by the public to see if in fact, their worst fears or any of their fears come into fruition. So I certainly want a tracking system. I'm not sure exactly what is being recommended here, but I don't think that needs to bar us voting for this motion.
Thank you. Any other comments? So let me just say that we've been joined by 2 board members since we started. Angela Pinsky, who's a mayoral appointee, and Marbury Solly Buff, who's a Brooklyn representative. So if we approve this amendment, then we will send the rules back for further review, and we won't be able to proceed with the vote. If we don't approve it, we can proceed and do what many of you said, which I agree with, is to get that grid of what the proposed comments represent, how they impact the rules as they currently stand, and as we proceed along the way, make adjustments and changes, as we will need to do with the matrix, as all of these documents are living documents, and as we try to refine and get better at what it is we've been charged to do. So I'm going to, Mr. Dwyer, I'm going to encourage my fellow board members to not approve this amendment, but out of deep appreciation for your wanting to make this process as good as it possibly can be. Are there any other comments? So all those in
Fred, I just want to say that thank you to the other board members that did comment. The comments were very thoughtful and it did explain it further. So I appreciate those comments.
Okay.
I would just not insignificant, but I would just mention to Mr. Siegel, because I think it's important that the public knows this, that an attorney from CCRB did participate in meetings around the creation of the matrix. So it's not that the CCRB voice was not heard. We can, at some point learn about how much it's heard or not heard, but this was not just a totally isolated thing. A CCRB attorney did participate in meetings concerning the disciplinary matrix with the police department.
So noted. Thank you. Are you all ready to vote? All those in favor of the amendment, please say aye.
Aye.
All those opposed to the amendment, please say no. The amendment fail, although any abstentions? Okay, the amendment fails. So thank you, Mr. Dwyer. Did you have another one you'd like to propose?
I do. So I won't take a lot of your time. I'll make up for at least a few meetings where I sit silent to just listen. A second, much smaller matter that concerns me, but a very important one in my mind, concerns definition. And definitions, I think we all agree, are very important. So as you may recall, as my fellow board members may recall, in 2018, I voted to approve the inclusion of allegations of sexual abuse within the jurisdiction of CCRB. I did so first because I thought it made sense, it was right, and I always thought it was implicitly present anyhow, so I just never, I mean, it's important. But so let me be explicitly clear, I support us investigating those. Having said that, I am concerned about this definition that is in here concerning sexual abuse, sexual misconduct. And I draw upon an analogy, a court case, a federal court case in New York, I think about 25 to 30 years ago, one that I would not be surprised even if Mr. Dunn were involved in litigating. And I thought the issue involved begging in the subways. And I thought the federal district court judge who heard it was very wise when he said, he quoted from one of the great songs of the horrible Great Depression. And he said, the line, "Mister, can you spare a dime?" cannot be criminal. And I thought there was great wisdom in that. The case went up to the circuit court and it got muddled up. But that line has always stuck with me. Things such as, "Mister, can you spare a dime?" Could not be criminal. When I look at the definition we have regarding sexual misconduct, it's on page 12, at least as I print them out, much of it I agree with. Verbal harassment, terribly wrong, not acceptable. Sexual physical gestures, the same, terribly wrong, not acceptable. However, when I come to a sentence that stands by itself and says sexual or romantic propositions, I cannot help but think of the obvious. "Miss, can I buy you a cup of coffee?" is the equivalent of, "Brother, can you spare a dime?" So I think the definition needs greater clarity. Unwanted sexual or romantic propositions, aggressive, rude, but definitions count. And when we write definitions that are not specific, then we take the chance of, at some point, the draconian board invoking them in a way that is not consistent with what law and justice should be. So while I think the whole definition is definition here is worthy of consideration, I would simply, at this point, motion that we add the word or words. I'd like to hear what others like to add. Unwanted. Unwanted sexual propositions or unwanted romantic. In other words, rude or unwanted, aggressive or unwanted or rude. But just to have a definition that says a sexual or romantic proposition is to me the equivalent of, "Can I buy you dinner?" And I can assure you about 1/3 of the police department would not have a partner in life if they were not allowed to say those lines. So I have grave concern about that definition.
We can, and then two comments on that. One is that we as board members, when we get these cases, will have to have our input on the severity, the significance of any of those comments that come under this category. In my last panel, we actually had such a case where a person complained about an officer asking that person out on a date. It was inappropriate, as we determined, and should not have happened. It wasn't aggressive. It was weeding for an officer. So I think we should leave ourselves the room to make these decisions as a deliberative and in some ways judicial body when it comes to adjudicating these types of cases. The other thing is, if we indeed, after these rules are implemented, find that we need to make some adjustments, as we said with the prior amendment, we can make those changes as we go along. I don't think the public's going to let us get away with not reviewing both this document, these rule changes, and the matrix, and anything else that we use to guide our investigations and adjudications of these complaints and cases. So I would make adjustments and comments. Any other comments? Ms. Simmons?
Yes. I disagree. I believe that any public servant, notice I say any public servant, not just police officers, any public servant during the course of handling their duties should not be involved in any propositions, be they sexual or romantic, to the people supposed to be serving. I think it's unprofessional and it's out of place and it's a misuse of their authority or their service responsibility. This is not just police officers. The same rule applies to social workers, teachers, etc., etc. So I don't have any issue with this because everything we're talking about in this rule talks about police officers doing things in the course of their duties. We're not talking about off duty, they go to some event or they're walking down the street and they see somebody and they ask them out. We're not talking about that. We're talking during the course of their duties. So no, I disagree. And I'm against the amendment. Oh, one other comment. I don't believe you can change one word without going through the process again.
That is correct. Ms. Dolly-Butts?
Yeah, I would just echo what's been said. I also think it's important to name that the kind of defense of like it was wanted or desired on both parts is really like there's a long legacy of folks who have been guilty of sexually harassing other folks and have used that as an excuse. And I think that in a power relationship, which police have when they are on duty, that this idea that somehow we can gauge what is not wanted, I think is a real miscalculation and understanding of how power plays out. And so I would just strongly agree the language as is sufficient. And I think that we have all powers of discernment as we go through cases. But I do think this is about a total power analysis and the power that police have when they stop somebody, when they speak to somebody, when they are armed and on duty.
Thank you. Anyone else? So we didn't actually get a motion on that amendment. Do you want to make a motion, Mr. Dwyer? And I think you're on mute.
Yes, I do. Yes.
Okay, so there's been a motion. Is there a second? It's been seconded. All right. All those in favor of revising the documents to reflect Mr. Dwyer's suggestion that we add, what were the words again? Unwanted and
rude, unwanted, harassing, and any others I'd be welcome to add that my colleagues would. But look, just to make it simple, rude, harassing, unwanted. I'd certainly be more than willing to add others.
It's been made and seconded. All those in favor of that amendment say aye or raise your hand. All opposed?
Nay.
So the amendment fails. Thank you. Another one, Mr. Dwyer?
Yes, I draw attention to a sentence that was added at the end of section 1-52, which doesn't involve sexual abuse or official misstatements, and I have no idea where it came from. It says a board member must not abstain from voting unless a member is subject to subdivision A of this section. And subdivision A, just to summarize, it is a personal relationship with one of the people or perhaps corporations involved. And first of all, I'm not aware of any issue around this. I've never heard it raised in a public meeting. I've never heard it raised in the executive staff that there's an issue around board members not voting. So to suddenly just find this gratuitous thing shoved in there, I find very peculiar, because I would have thought we would have gone through some process of discernment in executive session if there were a problem. But I would point out there are numerous reasons a board member would not want to vote. If they felt that the legal research, for example, was inadequate, if they felt that there were ethical concerns, if they felt, though they didn't have a personal relationship, let us say, God forbid, one of us had lost a 6-year-old child and the case involved the death of an 8-year-old child. Well, there's not a personal relationship, but I still would not want to vote if I was such a person. I can't think of, maybe one of you can, organizations that demand people vote. I mean, Congress, they don't have to vote. Senate doesn't have to vote. City council members are told they have to vote. But suddenly this statement appears in our document, and I don't know why. So I motion that it be removed from the document.
Mr. Chair, can I just address one thing? I was speaking with the general counsel who alerted me to Mr. Dwyer's concern, and in that situation, if there was someone who was uncomfortable with voting for a reason that isn't included in the rule, they could make a request to the executive director or to the chair, and we can reassign the entire case to a different panel. And I can assure you, Mr. Dwyer, that should that request come to me, I will make sure that happens.
And Mr. Dosh, I have total faith you would, and I have total faith our chair would. But as we've learned in recent history, well, let me take that back. As we've seen in history at different points over the years, we never know who power is going to be given to. We will never know how they will act for it. So I just go back to a statement I made earlier, which is, let us not put in words or definitions that could be binding on future generations that we would not want binding. So I'm appreciative of your thoughts and sentiments, but I just don't see a reason that it should be there.
So there's a motion been made. Is there a second to that motion?
Fred, I'd second that, but I would just like to know what was the thought process behind putting that in. After Frank brought up all those other bodies, federal legislative, doesn't have that. Why was this put? I'm just curious.
John, you want to address that, or does Matt want to address it? You're on mute.
So I think it might be better to actually promote Mr. Kadushin to the panel and let him address it as the general counsel.
Soren, can you do that? There he is. So, Matt Kadushin, our general counsel, you want to comment on this?
So let me just say that this is a warning to wear suit and tie to all board meetings, regardless if you are supposed to be on, not on camera. So I'm gonna. So I think this is a. But we observed in the panels that there were instances where people were just not voting despite having read the cases and deliberated in the process, and we thought it was a better way that there is a means to abstain, and the abstention is specified in paragraph A, and that the abstention shouldn't be used for any reason that the board members wanted to, because we needed the panels to move forward. I would note that in all the panels, if the board members were uncomfortable with a case, they can request any case at any point in time that they go to a full board, and that's the right of any board member to do. And in reference to Mr. Dwyer's point, that if a board member is uncomfortable with a particular case, it can be removed prior to any vote taking place or of a board member reviewing the case. And this is just a process to make the panels more efficient and work smoothly, and to record votes as yes or no, and to get board members to set forth their opinion on how they want to proceed in the case.
Thank you. Other comments?
Yeah, I have a comment. I think that Frank's point to me is well taken, because I did not have an understanding that this was a part of the rule changes that would be happening. I thought this was about adding the ability to review sexual misconduct cases. And so I think that notice should have been given to the board about other aspects of rule changes that were made. And so this is somewhat of a surprise to me that this is in there. You know, I would have preferred just to been aware. And I'm not talking, and I know you've given us the rules and what the changes were, but I mean, this is a change outside of the scope of what was mentioned, what this was supposed to be. So I think it should have been.
Corinne, if I just can add, one of the other big issues with this in terms of doing this is not to have 1-1 votes in the panel, because if it's a 1-1 vote in the panel and somebody's abstains and neither person requests that it go to a full board, there's no disposition for the case. And so that was also happening. We were having situations sometimes where it was 1-1 in the panel, and sometimes board members had not had an opportunity to review the case and didn't feel comfortable voting, but it created a situation of a possible 1-1 tie. And so we just, there's no way to resolve a case that's voted 1-1. And we just...
I understand. There's been times when I have not been able to vote because the body worn camera footage was not, the technology wasn't working and the footage was freezing, or I was supposed to get a report and I didn't get a report. And so there's other things that I just would have wanted to have taken into consideration when considering that particular rule change.
Thank you, Ms. Irish. Other comments? Are we ready to vote? All those in favor of the amendment that is the amendment, Frank, that we remove this link? I'm sorry, Ms. Simmons.
I want to point out again that if you change a word, that the whole thing goes back.
Understood.
It undoes everything about the rule changes. So it's not just we want to amend, we want to stop the whole process.
Right.
That's the effect of it.
Understood. And I would encourage us, to your point, to deal with these issues and others that are going to arise on the other side, on the many times that we'll have to address these rules and the matrix in the months going forward. But having said that, we have an amendment on the floor that has been made and seconded to, is it to remove that language, Mr. Dwyer? To remove that particular language. So are you ready to vote? All those in favor of the amendment to remove the language as articulated by Mr. Dwyer, please say aye or raise your hand if you're in favor of removal. All those opposed?
Opposed.
I lost you. There you are.
Mr. Dwyer, you're muted.
You're muted still.
Mr. Chair, I have a number of other concerns, but it is quite clear to me that while there's wisdom in getting them on the record, my hope is that we will move forward looking at many of these things very carefully. So I will not, I do have a substantial list here, but at this point I will concede the floor and just say that I do hope we get to review these and many other things in the future.
Sure. Thank you, and I hope you'll share them with us, the rest of them with us, so that we can consider them, and we will have these periodic checks along the way, again, on both of these documents. So we have a motion on the floor to approve these rules, and the motion's been seconded. Is there any more discussion or comment? All right, hearing none. I'm going to ask everybody to unmute and vote by voice vote. All those in favor of approving these rules changes, please say aye.
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 All those opposed, please say no.
No.
All those abstaining, please indicate by saying abstain. All right, the motions pass, and the motion passes, and we have the rules changes now approved. That is the only business under our agenda. Is there any new business to come before us? All right, hearing none. Is there a motion to adjourn to executive session? So moved. Is there a second?
Second.
There's a second. All those in favor of adjourning to executive session, please say aye.
Aye.
Aye. Opposed, no. The ayes have it. The motion passes, and we will now adjourn to executive session. Thank all of you. Thanks to the public that has joined us for this meeting. We look forward to seeing you at future meetings. Thanks again to the board members, to the staff, to everyone who made tonight possible, or this evening possible. And now we will go to executive session with board and staff.